Good afternoon, everybody. Welcome to 39 Essex Chambers. We are vaguely in person, which is a nice change. I am Celina Colquhoun, and on my left is Katherine Barnes. She is one of the UK's highest rated planning genies under 35. I'm a bit older. That's where I'm going to leave that subject. The topic for today is, as we say, back to basics, highways, public rights of way and village greens for planners. It's an area of law, both highways and village greens and commons, that is often deemed fairly esoteric as well as befuddling, which is all right for people like Katherine and I, but it can drive those of us in the planning the field to distraction when you're trying to get something practical done. So we thought that it would be helpful to have a back to basics session, and I hope that it's going to spark a few questions, which of course we'll have time for at the end. Katherine's going to start looking at public rights of way, and then I'll pick up on a few general points just to take you through that. If any questions come that we aren't able to deal with in the time or that we can't immediately deal with, please let us have them and we can get back to you through email or otherwise. Anyway, over to you, Katherine.
Thank you, Celina, and thanks everyone for giving up your afternoon to listen to us talk about highways. I'm going to deal really with how the rights arise in very basic terms, and then Celina's going to pick up more with what that means in practical terms when you've got a development affected. So I suppose the first really basic question, how do you know whether a site is subject to a public right of way? And really there are two options. The easy option, if you like, is where the public right of way has already been formally recorded. And if it is formally recorded, it will be on something known as the definitive map. And effectively, local authorities are required to keep and update a definitive map for their particular area. So you would need to check that for your site and see what's recorded. And the other important point to flag is that the definitive map's really quite significant because that's treated as conclusive. So in other words, if there's a public right of way on the definitive map, that's that. So unless you can amend the definitive map, and Celina's going to come on to talk about that, that is what the position is. So that, as I say, is the more straightforward possibility. But it doesn't just end there, and I really can't stress enough how important it is to look into these questions broadly. Don't just assume, oh, well, there's nothing on the definitive map, so there's no problem. Not quite that simple. The law provides for rights of way for the public to accrue over a period of time, even if they're not actually yet formally recognised on the definitive map. And the main way that that happens, it's now recognised under statute, is under section 31 of the Highways Act. So I'll just read out the key bit. Where a way over land has been actually enjoyed by the public as of right and without interruption for a full period of 20 years, the way is deemed to have been dedicated as a highway unless there is sufficient evidence that there was no intention during that period to dedicate it. So I'm going to look now in a little bit more detail at what some of those terms mean. So the summary position is essentially, if there's been 20 years of public use, then there is a presumption that the landowner has dedicated their land to the public, unless there's evidence to the contrary. And really, in a nutshell, the idea is that if a landowner lets people walk all over their land and use it to get from A to B for 20 years and doesn't do anything about it, they've had 20 years to stop it, then it's reasonable to infer that they were happy for the public to use it in that way. In other words, that they were effectively dedicating the land to the public. And some really important key elements, and when I come on to talk about village greens, they come up again. It can't just be any use, it's use as of right, which is rather a term of art. But effectively it means the use can't be without force, secrecy, or permission. So in other words, the public have got to be brazenly and openly using the land. If they were, for example, breaking over fences to get into the land and use it, then that would be by force, so it wouldn't be as of right. If they were using the land at night time under the cover of darkness, or maybe they were kind of hiding in the bushes, well, the without secrecy requirement wouldn't be met. And if the landowner said, you've got permission to use the land, or maybe we'll come on to notices, but put up notices saying the public are allowed to use my land, then that element of the definition won't be met either. So that's the first thing to think about. Then the use has to be without interruption. I mean, that doesn't literally mean that 24/7 the way's got to be in use. It just means continuous use in the sense that there's no actual prevention of the use. So for example, a locked gate, that would stop the use being continuous. In terms of the extent of the use, or the extent of the right, that really depends on the way that the public have been using it over the 20 years. So if it's being used by foot, then the right will be to a footpath. If cars are being used, or I mean, there's a whole range of things, it could be horses, God knows what, that will dictate, the nature of the use over the 20 years will dictate then the extent of the right that crystallises at the end of the 20-year period. What is this 20-year period? You can't just randomly pick 20 years. It has to be the 20 years preceding the date when the public's right was brought into question. So I've put various ways that the right can be brought into question on the slide, but that's the period that you need to examine, and it's calculated retrospectively from that date that the right's brought into question. Really importantly, and I'll come on to this again shortly, if at any point during the 20-year period the landowner puts up notices or a notice making it clear that they had no intention to dedicate the land as a public right of way, then the right won't accrue. So that effectively rebuts the statutory presumption, that presumed dedication that section 31(1) is concerned with. So notices are a really useful tool for landowners to think about. And then I've also just mentioned, it's quite unusual to be honest, but I've mentioned the common law position. Normally when rights of way occur over long use, it's under the Highways Act, section 31, but it is theoretically possible for them to accrue over shorter time periods, any time period under the common law. I've had to consider it when advising it. I've never actually come across a case where, I don't know, Celina might have, where I thought the test was satisfied. And typically that's because, yeah, it's very hard. There's no presumption of dedication, unlike in section 31. So you would need evidence that the landowner positively intended to dedicate land. And in practice, that's just quite, I mean, I'm not saying it could never happen, but it's difficult to show. So that's a whistle-stop tour of how the rights can arise. What then happens if you're a member of the public and you want to make sure that these rights aren't just theoretical, you want them to be recognised? Well, really, you want to get that right as soon as possible recorded on the definitive map, so there's no doubt about it. And there's a set procedure for doing that. You'd make an application for the map to be modified to add the public right of way, and that's an application under section 53(5) of the Wildlife and Countryside Act, and there's a specific procedure set out in Schedule 14 for doing that. And really, in a nutshell, it's then for the local authority. They'll consult on the application, they're required to investigate it, and then they will determine it. And I think there's sometimes a bit of confusion about this. They can't decide whether they think it would be desirable to have a public right of way. I mean, there might be really compelling reasons for a particular community why it would be nice. They can't look at that. All they can look at is that legal test in section 31 of the Highways Act or under the common law for whether public rights of way have accrued. So there's no discretion. It's just, do the facts of this case meet the legal tests? I put SA, it's surveying authority, but really it's just the local authority. They might refuse to make an order because they don't think the tests are met on the evidence, and if that's the case, an applicant can appeal to the Secretary of State, and there may well be an inquiry if there's something worth looking into. Or if the authority decides to make the order but it's opposed, typically by the landowner, then it would need to be confirmed by the Secretary of State, and again you may have an inquiry to look into that in more detail. Turning then to look at things from the other end of the telescope, from a landowner's point of view, what might you do to try and protect your land? Well, a very obvious thing to do and important is to lodge a notice under section 31(6) of the Highways Act with the local authority. And there's a set form for doing that. I think, yes, I put the link on the slide. And the effect of doing that is that if you like, it stops the clock. It wouldn't prevent any public rights of way which have arisen. So if you've had 20 years or more, if the test has been met, that right exists. But it's going forward for the next 20-year period. It's making it clear that the landowner has no intention to dedicate land to the public. So it's to protect the position going forward. Another important tool for landowners, notices, and I've put a picture of an example notice. Actually, there are lots of these around Lincoln's Inn where Celina and I, because all the lawyers live around here, they're sort of very keen on their notices. But as I said, under section 31(3), the effect of a notice, an appropriate notice, is to rebut the presumption of dedication. You need to be very careful that the wording, though, is right. So it can't just say something like private property. That courts have held that wouldn't be specific enough. It needs to say something like no public right of way. So effectively, people can still use the route, but it's making it very clear there's no intention to dedicate that land to the public. And I would suggest, if it's a sort of relevant issue in respect of a particular site, just get into the habit of documenting these notices. Take photographs, dated photographs of them, when they're put up, document the date, and it may seem a pain at the time, but in a few years' time you may be incredibly grateful that you went to the effort of recording that information. So moving on to village green rights, which I'll try and do a bit more briefly. The test for the establishment, the right to register a village green, is in section 15 of the Commons Act. And the right to register will arise where a significant number of the inhabitants of any locality or of any neighbourhood within a locality have indulged as of right in lawful sports and pastimes on the land for a period of at least 20 years. So again, you're probably seeing some similarities with what I've just talked about. So you've got to satisfy that test and also either have that recreational use continuing at the date of the application, or have the use can stop, but then in England the application has to be made within 1 year, and in Wales 2 years. Again, it's worth just unpicking the requirements in the subsection that I just read out. We've got this concept again, use as of right, which I've already explained. So it's not just any use, it's got to be without force, secrecy or permission. Again, we have this continuity requirement and sufficiency requirement. So there's, and really the way I think to think about this, because it all depends on the facts of a particular case, but the point is that there needs to have been enough use in terms of frequency, but also the level of use, for it to have been clear to a responsible, reasonable landowner that the public were using the land in this way and asserting rights, so that the landowner could have stopped the use or taken steps to stop the use if they wanted to. So it's about fairness to the landowner. They've got 20 years to act and sort it out, but it has got to be clear to them in that 20 years that something is awry. And clearly, just to be clear, there can be breaks in the use in a spatial sense or in a temporal sense. Spatial is not typically such a problem, because if there's a particular area of the land which is not being used, then the application can just, or the registration will just be made for a smaller portion of the land. But from a temporal sense, clearly if there's a, I don't know, 3-year gap where there was no use taking place, then you're not going to satisfy that 20-year criterion. Use in the form of lawful sports and pastimes sounds a bit anachronistic, but the courts have interpreted it in quite a sort of modern, pragmatic manner. So they've said it's recreation as part of normal modern life. So things like dog walking, playing with children, anything like that would classify. You don't have to be out there playing fives or rounders or cricket or some sort of old-fashioned sport. Significant number, again, really that's just about alerting the landowner to the assertion of the right, so it's got to be reasonably high number. Neighbourhood within a locality, I mean, really this is a very easy requirement to meet in my experience anyway. It sometimes looks a bit harder, but neighbourhood, really that's just a question of judgment. So and it will depend on the facts, but any kind of area where you've got shared facilities, for example, or there might be geographical boundaries like a road, that means that you can legitimately say there is a neighbourhood. There has to be a sufficient degree of cohesiveness. And then really the locality requirement is a bit of a non-requirement. Locality means any administrative division known to law, and the courts have said that it can be more than one locality. And so normally any neighbourhood, as long as you can show that you've got the cohesiveness to be a neighbourhood, almost by definition, you will be in a locality of some description. A final point just to add, and there's been some recent case law on this for village green geeks, there is the statutory incompatibility doctrine, which where the land is owned by a public body will probably need careful consideration. In a nutshell, if the land is held for statutory purposes, so it might be housing, for example, or education, and those purposes are incompatible with village green use, then you're probably not going to be able to register the land as a village green. So looking at it again from the two perspectives, if you're a member of the public and you think that village green rights have arisen, the way to get those formally recognised is to make an application for registration under section 15. I put the regulations in England, there's different regulations in Wales. Something very important to remember though is that registration will be precluded if a trigger event has taken place. A trigger event in England includes various things, but including when an application for planning permission in relation to the land is first publicised, and also when a draft development plan document which identifies the land in question for development is first publicised. And really this was introduced to prevent abuse of the village green rules by people objecting to development. So if you think that there is land in your area that really genuinely meets the village green tests, then I would suggest that you make the application as soon as possible and don't wait for it to be threatened by development, because once that application for planning permission has been publicised, you've lost your chance. Interestingly, in Wales, I discovered this only quite recently, the trigger event rules are much less strict. So there, the trigger event only takes place when there's actually been a grant of planning permission. So I don't know what Celina's experience has been. There was I found that when I first started practice, I had quite a lot of village green matters, and recently far fewer, although I have got one in Wales at the moment actually.
Which is why you get that trigger.
And I wonder if maybe this is something in Wales that, particularly as the rules become more known, that may become an issue for people developing land in Wales. And then finally, in terms of what landowners can do, rather like a notice under section 31(6) of the Highways Act, there's an equivalent under section 15A for village greens. So you can lodge a statement with the local authority, and you can see it says the effect of the statement is to bring to an end the period during which people have indulged as of right in lawful sports and pastimes. So it's actually a bit more generous than the position under the Highways Act. If your 20 years hasn't yet accrued, then a statement under section 15 will solve the problem. It will just stop time running. And so a successful application would only be possible if another 20 years clocks up. And if the 20 years has already been met, then an application would have to be made within the next year. So there's a sort of narrow window in which an application would have to be made. And it's the same form online as I posted earlier for public rights of way. And then the other thing that you can do, which is a really powerful tool, is erecting signs. Just be careful about the wording, the court. There's been quite specific about what your signs need to say, and I've put one particular form of wording that's been endorsed by the senior courts, which says the public have permission to enter this land on foot for recreation, but this permission may be withdrawn at any time. Which, if you think about the concept use as of right, makes sense, because as soon as the landowner is giving permission for the public to use the land and recreate in a recreational way, that use is with the landowner's permission, so you're not going to be satisfying the as of right test. So it's a nice way of the landowner protecting their rights, but also allowing the public to continue using the land in the meantime.
And that's frequently by right as well, isn't it? As opposed to as of right. That's how people kind of compare. I'm physically permitting you either through any agreement or through signs. So it's a quick way of saying I'm here by right as opposed to as of right. Anyway, I sort of interfered with you. This is my little section of the presentation. I have tried to pick through some of the issues that I've dealt with over the years with regard to highways and development, either developing highways themselves or in effect through issues that have arisen with trying to get planning development through, and or problems that have arisen after planning permission has been granted. So I'm going to try and cover a few areas. There are the Highways Act, as you probably, those who've had to dip into it know, is a huge act, and there are many aspects of it that I don't deal with, but I'm going to try and pick through a few of them. The first question I've asked is what is a highway, or you know, how do you decide whether something is or is not a highway? And I've given you a few pictures there. All of those potentially are highways. The first question, sorry, the first question I've got though, it deals with the legal extent of the highway. I was going to start looking at physical aspects, but I thought actually it really does come down to what is the highway as a legal thing. And the first and important fundamental aspect of a highway is that it must be a right that the public can deploy, and it's the public at large. So any member of the public is entitled to use that particular road, highway, street, whatever you want to call it for the moment. And that is to be contrasted with an owner of a particular property, an occupier of a particular property, or indeed the owner of the particular piece of road, as well as the lawful visitor to that particular property. And I've set out a reference to a case called, I can never pronounce this, Katherine Barnes, and that's probably not quite the right way to do it, but anyway, that was a 2012 case that looked at these aspects. The second important part is that it is the right of that public at large to pass and repass along the highway. And that is from a very old 18th century case. But also that is further qualified by an interesting case that happened back in 1999, when people were trying to object to the proposals then in relation to the A303 along Stonehenge. And those works came a lot later, and I'll come back to that much later. But what those who sought to assemble on the highway, they weren't actually in the carriageway itself, preventing people from driving up and along it, but were at the side. And they were duly prosecuted for obstructing the highway, and subsequently those convictions was overturned by the House of Lords, because what was suggested was that the right to use the highway isn't simply a question of keep on moving. You can, you know, as long as you're carrying out an activity, you have a right to be on the highway. And as long as you're carrying out an activity that's otherwise lawful and doesn't obstruct, then that activity can be something you're entitled to do, and that is not going to get you in trouble. If it was coming from a more civil aspect, I suspect that if you were actually trying to use the highway simply for a recreational activity, so if you were trying to use it for some of the activities you would normally be carrying out on a village green or common, that might get you into a bit of trouble. But the principal point about Jones is that it was a criminal offence and it was based on obstruction. And if you're not obstructing and you're carrying out any other kind of lawful activity, then you should be all right. The third point I put down is that it needs to be a known and identifiable route, and it's a route is the main thing there, I think, because it doesn't have to be a metalled highway. It doesn't actually have to be anything formal. It has to be a known and identifiable route, because we're talking about all kinds of highways. The other part of the right to the public's use is the extent of that use, so which to some extent is really more the classification of it, and Katherine has already touched on that. I've put forward the three traditional ancient parts of the common law that identify what you can have in terms of a highway, and set it out there. It's a common law. Highways are of three kinds according to the degree of restriction of the public rights of passage over them. So you have a full cartway over which you can walk on foot, or you can ride or accompanied by your beast of burden, and with vehicles and cattle. A bridleway, as those will be familiar with, is a highway over which the rights of passage are cut down by the exclusion of the right of pass with vehicles, and sometimes, although not invariably, the exclusion of the right of driftway. So a bridleway is not simply just for horses. And lastly, we have a footpath, is one over which the public only have a right of passage on foot. There are other titles that have since arisen since that ancient law, but those are the three principal categorizations of highway. Now, one of the questions that I've had to come across now and again is whether a cul-de-sac can actually be part of the highway. In terms of logic, it would, in many cases have tried to argue, well, it shouldn't really be, because it's not a, it's in its nature a very simple and cut off part of the highway or part of a road that only allows access to the owners of the property at the end or attached to or adjoining that particular route. Nevertheless, there are two cases I've mentioned there, White House, and then more recently Chandos Land. I say more recently, it's 1910. There's a lot of very old cases that you have to look at with those, that said that you know, once a user is established by the public, then that is a highway. So it is quite possible for a cul-de-sac to be a part of the highway. Lastly, and again, this kind of overlaps with the physical extent of the highway. It is the formal part of the nature of the highway is that it vests as a right in the highway authority. I've referred to section 263 of the Highways Act, which describes that the right that is vested as being necessary for its control, protection and maintenance for the use of the public. But that is a description given back in, as I said, 1896 through the famous Baird case. Now, for those property nerds out there, the right is in fact a proper legal rem. It is a determinable fee simple. So it's something that you can in effect possess as a highway authority, and that can sometimes, I think, be forgotten. It is actually a highway authority's possession. Now, oops, wrong one. Now, physical extent. Typically, obviously, we have, you look to a carriageway, which is where you will be doing your passing and repassing, but potentially, clearly, we're looking at a carriageway proper, in other words, that carrying vehicles. There will be a verge to that. There can also be verges to footpaths, but also there is this interesting part of the law that looks at roadside ditches. The fact that roadside ditches can sometimes provide a form of boundary in itself has actually often arisen as a query as to whether that creates the edge of the highway or whether it's part of the highway itself. And I may come and look at a couple of cases on that. Private rights of way, where do we find them? Those clearly, Catherine's referred to the definitive map under the WCA, but that description in the definitive map and the statement sets out the width of, should set out the width of that private right of way. If it isn't in there, then you have to look to other aspects. And sometimes it is said that there's a presumption that the width of that footpath, highway, whatever you want to call it, in terms of being a highway, is either of hedge to hedge or fence to fence. In other words, the whole area between those two features. However, there are three cases that I've set out there where this issue was considered, and a number of judges have gone from saying, well, their presumption really clearly needs to arise, you know, between that the highway is between each hedge or each fence, and that was rowed back from in Neild, and that presumption was described as being only if you have sufficient circumstances. So you have to take everything else into account before the presumption arises. And lastly, there's a case of Bainan that looked at verge in the same context. I've set out the words of Justice Hale, as she was then, which goes through the whole series of points about whether that presumption arises. I'm not going to read it out, but it is one of those where you can look to all of the facts, and that may include having to look at some extremely old maps and plans, and in particular looking at why it was that the hedge or fence was put up, when it was that the hedge or fence was put up. But once you've established there's a good reason that there's a relationship between the hedge or fence and the land on either side, and then the way that exists between the two, and that there was perhaps an obvious connection between that is the highway and the fence or hedge is providing that boundary, that is a presumption. And that can only be rebutted by saying, well, there is a good reason to suggest that hedge or fence wasn't there for that boundary purpose. The other famous bit of highways law that describes the physical extent, which deals with the vertical extent, is this point about the top two spits, or the Baird principle. And the spit, for anybody else who doesn't know, is a spade depth. The top two spits we will probably still continue to use, but it is now, as a consequence of a recent case in 2018, London Borough of Southwark and TfL, it is now known as the zone of ordinary use. And that describes, in effect, a little bit more, it's a bit more flexible in terms of where the right goes down to, and underneath the physical, perhaps physical sort of surface of the highway. There is also an above surface airspace characteristic to the interest that vests in the highway authority. It is this zone of ordinary use. It's a depth sufficient to provide for its support and drainage is an important aspect to remember that, because clearly there's going to be, when you're looking at most highways, there's a lot of infrastructure within the highway itself, but also what we call a modest slice of airspace. I wonder what a modest slice of airspace above it, sufficient to enable the public to use and enjoy it, and the responsible authority to maintain and repair it. So that is where we are with regard to physical extent. Thanks. Now, I've just had a list of other common classifications that aren't really classifications. If you're having to come across them, there is no real magic, I'm afraid, in any of those phrases. Trunk road, perhaps, and clearly motorway, and potentially unclassified county road. I've had to deal with that very recently. And an unclassified county road is something that existed some time before the 1980 Act. And one would have to, I'm afraid, look back to the Enclosure Acts and the time when roads started to become a bit more widely spread and also metalled, and we had a changeover in terms of who was responsible for them. Special road is not a term that is actually used either. I put it together with motorway, but they are not the same. It is the kind of the earlier justification, as it were, for that term. A highway is maintainable at public expense, and that is a term that is used a lot, clearly throughout the 1980 Act. But a highway that is not maintainable at a public expense is still a highway. And sometimes I find that local highway authorities, because it's not formally maintainable at a public expense, is not treated as a highway, and that is not correct, I'm afraid. The last thing, a private road or private street, you could call it a highway if you like, but it's not, which is why I highlighted that. So, looking at highway authorities, Section 1 of the Highways Act 1980, you've got two principal highway authorities. First, the Strategic Highway Authority, which is the Secretary of State for Transport, and the Secretary of State for Transport acts through Highways England, which is now a company, and that is responsible for the strategic road network. So in other words, trunk roads and motorways. The local highway authority, which for London is TfL, but specifically in relation to Greater London Authority roads, but elsewhere local borough, London Borough Councils, again, that's with the London, but outside of London, it is county or metropolitan district councils. They are the highway authority. In many, many circumstances, you will all be familiar with the fact that district councils often act, they have the power to act, to maintain and carry out various highway authority duties. But that is something that has to be agreed with the principal local highway authority. Functions and duties, well, there are many. I have not set them all out there, but the local highway authorities who are for all non-strategic highways, whether or not maintainable at public expense, which is the point I'd emphasise earlier, which is they are responsible even if it's not maintainable or formally maintainable at public expense. That's all set out at the beginning of the Highways Act. There is a general duty understood in law on highway authorities to facilitate the safe and unobstructed use of the highway by the public. And that is where all the duties to repair and maintain come from. It is ensuring that the public can pass and repass safely and unobstructed. The duty to maintain under Section 41 has given rise to a great deal of litigation. It is now seemingly settled. I am not going to go through it in any great detail, but it's important to be aware of it, and it can be something that planners and developers keep in mind when they're trying to construct their developments, and there may be issues as to how and what's happened to the highway. The duty to protect and assert the rights of user, that's Section 130, and indeed that deals with the obstructed part. And there are similar duties under Part 3 of the Wildlife and Countryside Act. Katherine has dealt with, in some sensible and extremely helpful detail, about the creation of highways. I'm not going to repeat that. Now, how do you find those highways? If you've got a site, how on earth do you actually identify it? Yes, of course, we can all look at a map, but in the first instance, the definitive map and its statements should provide you with those paths and highways. And indeed, we had a question just before before having this webinar that pointed to the fact that there was a footpath shown on a site, but it no longer formally existed physically, and whether that was a matter that could be taken account of, and the fact that there had been an alternative route already found. Now, the fact that something doesn't exist physically, or you can't see it on the ground, I'm afraid is no answer. The definitive map and the statement under Section 56 is the definition of where it is, and that is conclusive, as Katherine said. So it's really important to start there when you're looking at a site. Go to the definitive map and see what it is that is shown across your site, or even on the edge of it. I've talked about lists of highways. It's a very general point to make, but highway authorities themselves are required to identify where their highways are, and usually this will show the extent of that, usually marked in blue. There are also the district councils who are given the responsibility of carrying out maintenance. They will have lists and maps showing again the extent of the highways that they maintain. So that is a further indication of where you might look to see how the full extent of your highway, and indeed whether what you are adjoining or what you are entitled to access is really highway, or whether it may be still a private piece of land. Lastly, I thought it was sensible just to come back to this point that under section 31A, as Katherine said, if you want to be clear that you have not dedicated a highway, or if you consider that there is something amiss, then you must put forward a declaration, and that will be lodged, and you can find those declarations. So again, have a look when you are buying a site, or whether you're not fully clear as to what rights apply to that site. Go and have a look at section 31A list. A couple of issues. So firstly, you need to make sure about the impact from your development. The principal test remains, although it is slightly changed in 2019 under the NPPF, that if the development should only be prevented or refused on highways grounds if there would be unacceptable impact on highway safety, or the residual cumulative impact on the road network would be severe. Now, the new part to that in 2019 was the unacceptable impact on highway safety. Highway safety was always an issue, but the test was always that was the high one, that was the severe. So it is an either or. It is quite a high hurdle, though, that severe one. And indeed, I would encourage developers just to make sure if there are no issues on highway safety, then the residual impact of severity is quite perhaps a helpful one if you're trying to get a development across the line. Once you've carried out your assessment, if it's been established that you obviously you may need full access works, but if your access works have an impact on the highway, or indeed the impact from your development requires further off-site highway improvements, then clearly a close relationship with the local highway authority is going to be fundamental. The other thing to remember, and this is something that comes up now and again, is that sometimes the red line of your site stops short of the area that's needed for the highways works. You can get around this, but especially if you yourself are not building on that area of highways works. But in my view, it is far better that you incorporate, and indeed some highway authorities insist on it, that you incorporate that area of land that is strictly for your highways works within your red line, because you need planning permission. A highway authority does have permitted development rights to carry out improvement works, but you as a developer, or you as a highway authority concerned about works being carried out, needs to make sure that the planning permission is covered, or that planning permission has, in effect, can be granted for those works. Just keeping an eye on the time. The big point about section 38 and section 278 agreements, which we kind of bunch them in with section 106, is that they are clearly coming from two different directions. The section 38 agreement is when you want to construct a road for subsequent adoption. So you yourself carry out the works, and then you dedicate the highway to the authority. It's normal. That's the normal practice for internal state roads. So you carry out the works, and then you go. So this is now dedicated as highways. It allows a privately maintainable highway to become a highway maintainable at public expense. That the key thing there is that you must remember to dedicate, otherwise it will remain a privately maintainable highway, which you don't necessarily want. And section 278 is where highway authorities enter into an agreement with a developer for the execution of the works which are to be paid for by the developer. And this must be on the basis the highway authority are satisfied it will be of benefit to the public. Now, I've asked a few questions there about what if, what problems may arise over these two development issues. What if the highway authority objects and won't engage? What if you as a highway authority cannot see a solution to these issues? What if local planning authority takes a different view to the highway authority? What are the consequences of that? And what if you forget to dedicate properly all your section 38 road? Now, these are all matters that I cannot answer, and I think again in the next 5 minutes. However, they are all issues that are soluble. The main point here is that they can cause extreme problems with development, but that the earlier that these issues are spotted, the better. Now, let's just have a look at the time. We've got 10 minutes left. I think let's have a look at whether we've got any Q&A. Right. We've got a few questions which I suspect will be very good to ask. The rest of my presentation looks at what you do about private rights of way across your land, and also whether you know what highway authorities can do to create rights of way. But I think perhaps let's enter into the Q&A, don't you think?
I'm happy with that. Or if
otherwise,
we have time, you can at the end can continue, just round off a little summary if you want to.
Yeah. So let's just have a look. Firstly, what about discovering lost ways? Now, I'm not entirely sure what is meant by a lost way, but if you have a path or private right of way or something that looks like a footpath that has not been identified on the definitive map, and you believe that it properly should have been put on the definitive map in the 1950s, that is something that can be the subject of an order under the WCA. The difficulty is if it's not on the definitive map, it's very difficult for that. There's no presumption that arises. But I don't know, Katherine, whether you think that there are other ways of dealing with something that you realise should have been identified back in the 1950s when the work's carried out. And
I think it all just depends on the evidence. I've done some cases. I mean, they can be really interesting, actually, in a kind of geeky way, where you're looking back at enclosure awards way back. And ultimately, as Celina said, once a highway, always a highway. If that right has accrued, and you can positively prove that, then you should be able to get the definitive map amended, as long as that test that I took you through is met. It's just that obviously the further back you go, the harder it is to get the evidence to prove that. But that's not to say that it can't be done, archival research and so on. What about the next one?
Yeah, now this is really interesting. So the Finance Act was.
I think, do you want to read the question?
Oh, sorry, yes.
The participants.
Sorry.
Yeah.
So we were asked whether at common law would not a declaration that a way was a public highway under the Finance Act be seen as deemed dedication? The short answer is yes and no, because the Finance Act was, and the way that it treated highways was for a very specific purpose, obviously a financial purpose. The question as to whether that particular road operates as a highway with all the commensurate legal and physical extents is actually, in my view, very different. So it would always be part of the evidence as to whether or not what you have is properly a highway. But if, for example, a highway authority has never recognised in a plan going back to the time of the Finance Act that even if it has been drawn on the maps that accompanied the Finance Act, if it's only there and it's not anywhere else, for example, on ordnance survey maps, then that deemed dedication doesn't arise, because it's the purpose of the Finance Act was different. It wasn't in order to say this is a dedicated or created highway. So it would be definitely part of the evidential exercise, but not an immediate presumption. What's the next one? Is planning permission required for works to a road that is unadopted, also private? Is this still classed as a highway? Well, planning permission is required for works, full stop. And if it's a highway, a proper either public maintainable or a highway recognised as such, then it will be subject to either PD rights, or indeed, if you need to do further works, it would have to be through potentially through an order. Depends upon what it is that you want. But if it's a private land and you don't own it and it's used as an access way, then again you would need planning permission to use planning permission on that private piece of land to carry out the works. It really, I'm afraid, depends upon what it is that you want to do, but bottom line is development is development, and planning permission is required for development.
I mean, obviously, if it's the highway authority doing the works and there are improvement works within the boundary of the highway, then there's an exception carved out in section 55, so no planning permission required. But I don't quite understand what the question's getting at, but I think the point being, if you're a private landowner and you want to undertake works to your land, if ultimately that meets the definition of development in section 55, you're not a highways authority, so you're not going to come within that particular exception, then yes, you're going to need planning permission. And like Celina says, it depends on the work. If it's a bit of kind of repair work, well, that's not going to come as development. But if you're changing the route or the boundaries of it or whatever it may be, then it will be.
Yeah.
Right, what's the next one?
Just coming back to that question we were asked before the seminar, whether you realise that there has been a footpath on the definitive map, but it's now not even practical to use it, but there's an alternative that's perfectly acceptable. What would you do with that?
Well, I think you're just going to have to apply to amend the definitive map. As Celina said, if just because in practice, in real life, as it were, on the ground, a sensible solution has been found, I'm afraid in law, that's not going to help you very much. But I would have thought it's not actually going to be that difficult to modify the definitive map.
No, it's
in
just
circumstances like
it's
that.
just
in a way,
a procedure.
it's sort of,
you're going to have to go through it.
But it's an important procedure nonetheless.
But I think that's why going to the definitive map first, before you even even interested in the site, is a really important part of your research, because it can create all kinds of subsequent problems. Because some people do get very, very enthusiastic about the definitive map, and there can be strong objections. And if you find yourself, you build a house across a footpath, that could be really catastrophic.
This is quite an interesting comment, really. I'm sorry, I don't know the time. Yeah, we probably just need to wrap up, but should we
try this first one?
Yeah, so someone has commented, sorry, I'm saying someone because apparently for GDPR reasons we shouldn't say the name, but we have recent experience of highway authorities seeking section 278 works in addition to highway works identified in section 106 agreements, where perhaps these works would not have passed the relevant section 106 tests.
Okay.
Which is, I mean, I haven't personally come across that, but that is something to look out for, I would have thought, and that is quite naughty if you're trying to circumvent.
Well, it really depends when your agreement was entered into, because if the section 106 was entered into prior to or at the time of your planning permission, then it's supposed to pass those tests. And if the works that are being sought are not required as a consequence of the development, then again, that would be unusual. Section 278 itself obviously isn't subject to any SIL 122 test. So, but in just to pick up on the fact that because you can have a combination of section 106 and 278, and sometimes even 38 with it, depending on what you're trying to do. But principally, if you're agreeing to do works that aren't justified by your development, you could still carry them out under section 278. But because because 278 is basically a funding agreement.
Yeah, I think, yeah, I might be misunderstanding the question. I think if, well, yeah, I don't know. This is the problem when you do it remotely. But if the implication is that the highway authority is trying to circumvent the restrictions of section 106 by kind of requiring extra work, you know, where it's the basis on which permission is being granted, then that's quite interesting and something that obviously need to be careful. I mean, that's something that should be looked at when planning permission is granted. If there are particular highways works that are needed to make the planning impacts acceptable, then that's something that needs to part of the grant of permission.
I think what it might mean is that there's a 106 and there's a section 2, so that's not a combined agreement, and that these are additional works to that went through or passed through the 122 test. So I think that given that it's a funding agreement and doesn't have to necessarily be justified by the planning permission, I can see why that might arise. Whether you should agree to it or not is a different matter, but 278, as I say, is a different vehicle. Just there's one more here about whether an outline permission with an indicative master plan showing development over a private right of way, whether it would overwrite any requirement. No, it wouldn't. No, I'm afraid not, because the planning permission doesn't have that sort of power. You know, the definitive, I'm afraid, wins out.
And indeed, that's why, maybe we should end on this, that's why these issues are so important, because it can scupper a development right at the final stage. I mean, I'm not suggesting, in all likelihood, it would be possible to divert that public right of way. It's, you know, probably not a problem, but it may take a very long time. And indeed, it's possible that it won't be. So you could have this wonderful planning permission to do exactly what you wanted to do, but not be able to implement it.
And it doesn't mean that the planning permission is unlawful either. You can grant permission over it, but because it's a legal constraint, not a planning constraint. But it does mean that you're going to have to tackle it. Yeah. There was a further question, but I'm so sorry. I don't think we've got time. We've got time to deal with it. But we'll try and pick those extra points up. And indeed, if anybody's got any other burning issues that they wish they had asked, then please feel free to contact us. That would be our pleasure. Thank you very much indeed, and thank you all for attending. Katherine, thank you.
Thank you, Celina. Thank you, everybody.
Bye.